This is simply a very obvious case of discrimination due to your relationship with Rick Kofer, and I see that
Miss
smug look on
Dupuy,
your face, Mr. Gordon.
you have no idea what you're talking about.
I do know what I'm
If I
talking
can,
about. I
if I
know
can,
that Rick
In
runs
any
this
in any
county.
event, this hearing is over and
Welcome to Rebel Chaser. My name is Gail, and I've got 4 videos for you tonight. The first one is with Judge Soifer in Texas. I've never done a video with her before, but she's good. I liked her. The second one is with Judge Boyd, and you guys may have seen this on other channels, but Judge Boyd is so classy. I had to show it because she's just a classy human being. And then the third one is with Judge Ricky. This is a greedy mom. And then the last one is actually a really hilarious traffic one with Judge Chisholm. So I'll let you guys watch.
so let's go back to the Dupuy. There we go. All right, so the last thing I see in this file is dated May 22nd. And Ms. Rowland Finch, this is a non-evidentiary summary judgment motion, so we don't need a record.
Okay, thanks, Judge.
So I see that there's no response filed to this motion. And I know you're representing yourself, Ms. Dupuy. You said something came up on Friday. What is that?
So Friday was when I became aware that you were the judge sitting on this case. I've actually previously asked you to recuse yourself due to your relationship with Rick Kofer, who is a person with personal knowledge on this case. There's actually some very bizarre things going on in this case involving Mr. Kofer and the opposing parties. So Mr. Kofer, he's a personal friend of yours. I know that from Facebook, but I also know that in 2015, he also sponsored your initial run for office through sponsoring a fundraiser for you. I also know that he was the de facto heir apparent, I guess is the good way of phrasing that, to whenever you left your position as the Travis County chair of the Democratic Party, until it was discovered that he had assaulted a coworker in the middle of a courtroom, and that became public information. He withdrew shortly before that became public knowledge, um, and this was a big scandal. So, Mr. Kofer and our relationship began whenever he began representing a man named Bala Bahadra Alex Gravely, um, who, despite having a very Indian sounding, which that's where the name came from, name is a white man, um, who sued me in 2019. Miss Broussard, for some reason, has decided to contact Mr. Gravely and ask him to be a witness in this case. To my knowledge, Miss Broussard has never met Mr. Gravely. He came in and out of the property. She didn't even live here at the time, to visit me during the course of a relationship that I was forced into with
So,
him.
ma'am, I just need you to get to the point. What is it that you're concerned about? I understand that you want me to recuse myself. Is there something else?
Yeah, Rick Kofer represents Bala Bahadra Gravely in numerous criminal matters.
Okay, well, he's not a party to this action, and Mr.
He actually
Hofer is,
is. He's been called as a witness
okay,
in
that
this
doesn't
case.
make him a party. So he's not a party to this action, and Mr. Kofer is not counsel of record to any parties in this action. And as far as whether Mr. Kofer is a friend of mine or not, If we had to disqualify or recuse ourselves from every case in which I knew one of the lawyers for a witness or even for a party, I wouldn't be able to hear most cases because I've been practicing law in this county since I graduated from law school in 1982. So that's a lot of years. I know a lot of people. A lot of them supported my campaign. That's because I didn't have a viable opponent in part. And the bottom line is that is not a basis for a recusal, nor do I see that you have a motion to recuse on file.
Well, I only learned about this on Friday, so I have not had adequate time to prepare a motion in regards to
All right.
this.
You also haven't filed a response to the motion for continuance, motion for summary judgment.
No, I have been under extensive lawfare from Ms. Broussard involving two other justice of the peace cases, and additionally a criminal action in which she, a associate of hers, falsely accused me of assaulting him.
All
So
right.
I am under deep amount of legal paperwork at this point, and I am constantly calling lawyers every day to try to get them to take over this case for me because it's become apparent that I can no longer handle this myself because Miss Broussard's strategy, rather than responding to my discovery, was to send me a mountain of discovery requests that are nonsensical. If you go and read through the discovery requests, these questions that are asking are they contradict themselves. And then they also ask me for things that I asked her for. And then she does things like call my call somebody that me as a witness in order to harass and intimidate me. Like, and I asked for sanctions in regards to this, and I never got a hearing for that. I would call the previous judge, Judge Meacham, who is also a friend of Rick Kofer's, by the way. I would call the office and I would ask for a hearing in regards to my motion for sanctions, in regards to the calling Gravely as a witness, which he has
All
nothing
right.
to
Well,
do with this
let me
case. And there's
just,
no reason other than
Miss
to
Dupuy,
harass me to call him.
Miss Dupuy, there is a motion for summary judgment that was filed in this case in May 22nd. So it's been on file for almost 4 weeks. The law requires that it be on file for at least 3 before the hearing. Your answer was due 7 days ago. You didn't file an answer. I don't see a motion for continuance on file. I don't see a motion to recuse on file, and I don't see a response on file.
I did not learn that you were the judge on this case until Friday.
Mr. Vargas, you may proceed.
Would you like me to walk through the background of the summary judgment?
Yes, please.
Okay. So here, plaintiff and defendant Broussard own adjacent condos. Miss Broussard rents out her unit. Plaintiff resides in the adjacent unit. Miss Broussard started receiving complaints regarding plaintiff's unusual and confrontational behavior. And on October 27th, 2019, defendant's tenant, Miss Reyes, I forget her first name, filed a written complaint with defendant's property management company stating that plaintiff was aggressive and confrontational. Now, more specifically, plaintiff.
Okay, that's ridiculous because
Ma'am, you don't
she
have
had her dog try to
ma'am,
attack me.
ma'am, you don't have the floor. Mr. Vargas has the floor. You may speak after him.
Thank you, Your Honor. More specifically, plaintiff told defendant's tenant that she was not allowed to have a dog in the backyard of the tenant's own unit, and plaintiff said that she was to have access to defendant's backyard at all times. So this was obviously distressing to the defendant's tenant, who sought assurances from defendant Broussard by extension. So Ms. Broussard then sent a cease and desist letter to plaintiff advising her of the condo's rules as they apply to the backyard. So specifically, plaintiff is not permitted to enter defendant's backyard at any point in time. So this retaliatory lawsuit was filed almost immediately thereafter, and plaintiff asserts slander and slander per se, tortious interference, stalking, fair housing discrimination. And I do want to add, for the sake of clarity, that I wasn't the associate of record in this case until I brought this MSJ. Brandy Anderson was the other associate who Miss Dupuis was corresponding with. So I inherited the case from Brandy. And Brandy had sent plaintiff two different sets of discovery. There's nothing unusual about them. They're standard discovery requests. Plaintiff responded to neither. Actually, she had sent an email saying that they were in riddles. And again, I've reviewed the discovery requests. They're fairly straightforward. So Brandy, my predecessor associate, had filed a motion to compel on August 30th, 2024. The court granted this motion to compel on October 2nd, 2024, and plaintiff still hasn't replied to or complied with the court order compelling her responses to our discovery requests.
I don't see, oh, now I do, sorry. I see now. Go ahead.
Okay, no, that's about it. It's just we just haven't received any responses from plaintiff at all, and she hasn't sought to move this case along. She's had plenty of time to find an attorney. To the extent she complains about the criminal action, Ms. Broussard isn't involved with that criminal action at all. And here we stand today with no evidence with respect to any of plaintiff's claims for slander, slander per se, tortious interference, stalking, and fair housing discrimination. And that's all I have on my end. I mean, I can walk through individually all of the elements for the different claims if Your Honor would like to hear that.
Well, since there's no response on file, I don't think that's necessary.
Okay.
All right. So, Ms. Dupuis, why did you not file a response?
I have been completely underwater with Miss Broussard's extra judicial harassment activities.
All right.
It has been nonstop. She
Ms.
broke into
Dupuis,
my car again in February.
Ms. Dupuis, you understand that when you represent yourself in litigation like this, you're charged with knowledge of the legal requirements of being a party, right?
I understand that, but there is only so much humanly possible a person can do in any amount of time. I have been calling lawyers nonstop. I have become emotionally impaired to the point that this causes me post-traumatic stress disorder symptoms that she's aware of because of her conversations with Mr. Gravely.
Ma'am, you filed the litigation, so it's not that somebody filed
I filed it
litigation
years
against you.
ago, and
Yes.
many things have happened since then. And the timing of this hearing is very peculiar in the sense that I was in a hearing on Friday. I have a hearing today, and I have a hearing tomorrow. I have a lot of hearings to go to. Like, I can only do so much to prepare for each of these cases. And when you're calling attorneys and trying to find somebody to represent you, you spend 2 hours talking to, you spend an hour or two talking to a secretary, and then that person has a paralegal call you back, and then you talk to them for an hour, and then you talk to a lawyer, and then they send you a letter saying, we can't help you because we don't know how to do this. And, you know, again, I'm trying to get these cases consolidated because really have learned that, because of Mr. Gravely's involvement with Miss Broussard and her statements that she feels that she is entitled to act the way she is doing because she feels that Mr. Gravely has been falsely accused, which is bizarre behavior. Additionally, whenever we're talking about this tenant and the dog, I sent her property manager dozens of emails about this dog, and I sent specific provisions in the bylaws of our association in regards to how this dog is not allowed to be outside unsupervised. You can't leave a dog outside unsupervised. Not only that, this dog was being, it was incredibly hot. It was left outside with no water, no shelter. We had to get um, the
Animal
animal
control.
welfare authorities out there to look after this dog. It was being, and not only that, I do have access to the gate. I have never said that I've had access to Miss Broussard's yard. I have access to the gate that goes through her yard, and that is specifically provided for in the association bylaws. These discovery requests, they asked me for things that they already have. And also, they asked me for things that I asked them for additionally. And yes, half of the things that they wrote in these discovery requests were written in riddles. They were written in these like
All right.
yes
Right.
or no
I've heard enough.
way.
I've heard enough, ma'am. So the way a summary judgment motion works is if it makes a valid claim and there is no response to it, it is granted. I did not have an opportunity to review the motion before the hearing this morning. I will review it this afternoon. And if it makes a valid claim, then it will be granted. For future reference, ma'am, you can't ignore discovery requests. You cannot ignore motions for summary judgment. You have to file responses or you will lose. So that's how the system works. And I'm sorry you're busy and I'm sorry you have other cases. But this case has been on file since October of 2023. You're the plaintiff. It's your responsibility to push it forward. Having a motion for summary judgment filed after this period of time is kind of standard. And so
Well,
that is what we're going to do.
this
Without
simply,
without a response on file in writing, you have no defense to the summary judgment motion.
Thank you, Your Honor.
this is simply a very obvious case of discrimination due to your relationship with Rick Kofer. And I see that
Ms.
smug look on your
Dupuy,
face,
you have
Mr.
no
Vargas.
idea. You have no idea what you're talking about.
I do know what I'm
If I
talking
could-
about.
if
I
I
know
could-
that Rick
In
runs
any
this county.
event, this hearing is over, and I will. Did you prepare a proposed order, Mr. Vargas?
I believe it's on file with the court. I can double check. If not, would you like me to email it to the clerk?
No.
Okay.
It shouldn't be in file with the court. Proposed orders are not supposed to be filed. It should be uploaded into Box under your party's other matters. And if it's there, we'll find it. If it isn't there, then I'll ask you to go ahead. Mr. Beck, do you want him to email it to you? Or do you want
Yes,
upload it?
the email that you received from Ms. Fatima notifying you of how to join today's hearing, if you'll just reply all to that with the proposed order, that would be great.
Okay, got it. Thank you.
All right. Thank y'all. This
All right,
hearing
thank
is
you, Your Honor.
concluded. Y'all are excused.
Thank you.
Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Arlene Gay is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, and defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes,
Make its ruling, okay.
yes.
The
The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. See, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm gonna ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me, which is they're the one of third party,
Okay,
and I'm not. Well, I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual.
Yeah,
If it's
yes.
civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bear County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
Understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
All right,
Okay,
and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
yes, I am.
All right.
So the next document is entitled Court Constitutional Notice,
Mhm.
and that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right, do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you, the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay State Bar dues every year. And when that comes around every year, everybody's like, oh my gosh, State Bar dues.
Student.
Yes. So the State Bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir.
All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false State Bar, anything with regards to the State Bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this law.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, Your Honor.
All right, does that address that issue?
Yes, Your Honor.
I think the other issues deal on the second page, deal with the State Bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, Your Honor.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, Your Honor.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, Your Honor.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, Your Honor.
All right, so if you still want a jury trial, you're, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.
Hackett, titled in the matter of the marriage of Peggy Hackett and John Hackett. It's case number 2019 DM6. Peggy Hackett appears on her own Zoom. John Hackett appears on his own Zoom. This matter comes before the court at this time for hearing on a motion to modify child support filed by Peggy. Peggy, you've submitted with your motion a child support worksheet that you propose. I trust you believe that child support should be ordered in accord with that worksheet,
Yes.
right? John, are you opposing this?
Yes.
Okay, on what grounds are you opposing it?
On our agreement before, I was paying $650 a month plus the medical and half the benefits and everything, and that was agreed to when we first had our divorce for both children at the time when I was paying it beforehand. So then Rachel came with us and lived with us for 2 years. So I went to $350 a month, and she never said anything about that. Rachel moved back in with her. Rachel since then turned 18, and I figured we would just stay at the $350 with me covering medical and paying half the co-pays.
Is Rachel still have high school to complete?
Yes, she'll graduate in December.
She's at doing online course.
All right. Is there any response that you wish to give, Peggy?
Yes, Rachel is scheduled to graduate May of 2026. And she lived with JC from October of 23 to April of 25, so about a year and a half, not 2 years.
All right. Well, we're moving prospectively from here, not revisiting what's taken place in the past. And I'll first make the observation, if not a ruling, that child support is always modifiable, John.
Yes.
You may have reached an agreement to resolve the case at the time, but based on any change of circumstance or any circumstance recognized by rules, such as 3 years going by without a review, the court can modify child support.
Okay.
It appears that child support was extremely low. Are the income numbers in the child support worksheet correct, John?
Mine is 89,000 a year plus $280 every pay period for health insurance. So that's around 600, 288 times 2, what, 5 something, 580 a month that I pay for child or for healthcare and all the half the deductibles.
Okay. Where did you get the figure of $10,000 a month, Peggy?
It was an estimate. He has never shared his income with me. But from where we were at when we were married, his annual income, with the job changes, I just kind of assumed that it would have a small increase from where we were at.
What annual income figure was reflected by your W-2 from 2024, John?
Think 99,000.
Okay. Which is considerably more than the 89,000 that.
Yeah.
Okay. It does appear that it is appropriate for this court to review and increase child support in the case. I'll note the motion was filed May the 15th. Court will make any increase in child support effective June 1.
Can I continue and hire an attorney to follow this process? Because I just moved here to Florida or to Oklahoma, sorry.
Oh. Well, essentially child support's mechanical calculation. I do want to make sure we're using accurate numbers. I'm going to require you to provide your 2024 W-2 statement to
Yes.
Peggy. Are you going to continue to represent yourself?
Yes.
Okay.
And I would like to add, Judge, if I may, I now have 100% custody of the girls. He moved 3 hours away 2 weeks ago. So I had to put 85%, but now I have them 100% of the time.
All right. That will need to be provided to Peggy within 14 days, John.
Okay.
And I don't know, where did you get your domestic income figure, Peggy?
From my taxes, like it showed in the directions.
Okay. Well, I'll note on my docket sheet, my ruling that whatever increase that goes into effect eventually will be in effect as of June 1. We will set another hearing. You can obtain legal counsel if you so desire, Mr. Hackett.
Okay, I will be seeking legal counsel.
Because I don't have an accurate worksheet before me. And obviously, I'm going to ask John, do you have income besides your regular job?
No, I do not.
Okay.
And I believe she has income as well, other than her job.
Well, in all fairness, Becky, you should be providing John your whatever record you referred to determine your monthly income figure. It has less impact on the overall computation, but again, we want to base this on accurate numbers.
I think he's referencing that I have a roommate to help offset costs, but like you noted, the child support was significantly low. So I've had a roommate that moves out October, but that's not income.
Okay. How much time are you requesting here, John?
Say a week or 30 days to get a lawyer set up, or however long you think it would take there. I'd say within 2 weeks.
You better give him a month.
A month? Okay.
Is he allowed to have additional people in the room coaching him, or is it only supposed to be him on this hearing?
It's only him on this hearing.
He has an additional person that keeps making comments in the background.
Well, this is your case, John, no one else's.
Yeah, that's right.
I'm looking at Monday, July the 14th. And unless my assistant vetoes it, I was going to set this hearing for 2 o'clock. Mandy, I trust that's still available.
It is, Judge.
Okay. 2 o'clock on Monday, July 14.
Judge, is he allowed to continue with no payment? His last payment of $175 was on May 9th.
How come you're not paying on time, John?
I can make that payment. I just thought we'd go through the court deal, but I will make the payment, sir, right away after we get off the phone.
And because we've continued this to July, there needs to be a payment made at least at the old rate at a minimum.
Yeah, I'll take care of it. I'll get it all caught up, sir.
All right.
Judge, you're referencing the $650 then, not the $350 he was paying for a single child?
That's the current order of the court.
Okay.
There's no order for $350.
Okay. We'll take care of it.
All right. All right. Monday, July 14th, 2 o'clock by Zoom. And the court will undoubtedly need access to the pay information that I've asked each of you to disclose to the other.
Okay.
You can go ahead and send that same information to my assistant.
Okay.
Her email address, so it's available for me for court. And then Peggy, I also trust that once you receive his pay information, you'll compile a new worksheet.
Yes.
All right, you can submit that in the same manner, but make sure anything that you send to the court, John has.
Yes, I provided him a copy.
Now, obviously, if an attorney gets involved, you would communicate only through his attorney at that point.
Correct.
Okay.
As long as I'm notified.
Yes, and you should be.
And I provided him that worksheet prior to this hearing.
Yes.
Just so
And I read it.
All right. All right, Peggy, anything else we need to address today?
No, I just asked that we would continue Rachel to June 1st of 2026 post-graduation. That's anticipated.
That'll be a ruling that I'll make after hearing from both parties on July the 14th.
And then just that he'll continue medical coverage. He did have a lapse in that as well.
Yep, starting with the new job, but it's getting taken care of. They've already been accepted and payments been made.
And I trust you'll be receiving some sort of card or documentation. that
Yes,
you have
sir.
coverage.
Yes, they
You
haven't
provide
sent
that
those.
to Peggy.
Yes, I will, sir. I always do. So she has medical coverage for the girls.
Okay. Very well.
That's all, Judge. Thank you.
All right, we'll review matters Monday, July 14th, 2:00 p.m., where the court hopes to settle any and all child support related issues at that time.
Thank you.
We'll see you by Zoom at that date and time, folks. If there's nothing further, the Hackett matter will currently be in recess, and this meeting may be ended for all at this time.
This is citation 25 RO02405. Mr. Scorzo, you were cited for making a prohibited turn back on the 18th of April, 3:15 in the afternoon, 13 Mile and Crooks. You've got three options this morning. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I don't want to admit.
You don't want to admit.
They did anything wrong. That I did anything wrong.
I'm hearing two sets of voices. There's only one ticket issued. You need to speak to Drake Scorzo.
Yeah, I don't want to admit that I did something wrong.
Okay, then raise your right hands. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Okay, the officer will testify first, please.
Our magistrate, on the 18th day of April, I was working a traffic detail. I was positioned in the area of 13 Mile and Crooks, monitoring traffic for the no left turn due to construction. I observed a 2021 Ram 1500 perform the prohibited turn, crossing the double yellow line. I stopped him and cited him for the violation.
Scorzo?
Yeah, so I was on 13 Mile Road making the left, and there was construction everywhere. I didn't see a sign, and there was cones in the left turn lane. So when I got up there, I was in the middle lane, and there's no like oncoming traffic or anything. So I made that left turn, and that's when I got pulled over. I mean, I didn't really cause any harm or anything, and I wasn't sure because I'm not from the area. I live like 30, 40 minutes in Northville. And then he pulled me over and said he was stationed there to just kind of pull over people who were doing what I did. And I just kind of felt like it was kind of like entrapment with like the construction zone, like not really knowing what to do there.
You're serious. You consider that entrapment? For you to drive by multiple no left turn signs, make a prohibited turn, and then you say the officer is trying to entrap you?
Well, I just really didn't know what to do in that kind of situation.
When you see a no left turn sign, what you do is you don't make a left turn.
I didn't see that left turn because my direction.
Did you go back and find the multiple signs that were there? Did you go back and look after you were stopped?
No, I wasn't. I wasn't from there.
Left turn was closed. Can I speak? Ask if I can speak. Drake, ask if I can speak.
It's absolutely
4.2.
clear that you made the turn. It's absolutely clear the turn was prohibited.
Left turn wrong.
And despite the fact that you don't want to admit you did something wrong, you did. And the fine is $130. The points are between you and the Secretary of State. The court has nothing to do with the point system. We're done. You can pay it online or by mail.
Judge, can I speak? I'm his father.
No.
Because left turn lane was closed. How was he supposed to make the left? The left turn lane was closed.
Because there was a sign that said don't turn left.
He didn't see the sign. The left turn was closed. He made a left-hand turn.
Were you in the car with him?
No, but I
don't know what happened.
I seen it. The left turn lane was closed. This kid with a 4.2 GPA, National Honor Society.
Then he ought to be able to read a sign, shouldn't he?
Well, maybe.
I want to admit I did something wrong.
Okay, so the first case with Judge Soifer, that plaintiff would still be talking right now if she was still in front of the judge. She'd still be rambling on about nonsense. She rambled so much, I didn't even know what the case was about after a while. I still don't know what it was about. She was she owns a condo next to somebody else, and they both rent it out, and I guess there's issues with the rentals. I don't know, but she confused me. The second one with Judge Boyd, I know you guys probably have already seen it, but if you haven't, Judge Boyd is so classy. She never once rolled her eyes. She never once belittled this guy. And you know he was put up to this by people in the jail telling him, yeah, do this, it'll work. They know it won't work. Now this guy has everything explained to him, every single aspect explained perfectly. He looked like he understood. But I don't know. Next time he might come back and spew some more garbage. I don't know. The one with Judge Ricky, that mom, she seemed like she was so controlling. She wanted to control who was in the room with her ex. And she just wants money. That's all. She just wants money. She doesn't care about the relationships between daughters and dads. She just wants the cash. And then the last one with Judge Chisholm, he brought his dad with him. And unfortunately, Dad just made it worse. Dad just made it look like they were both idiots. I mean, when the left turn lane is blocked, what do? How do you make your left turn? You don't. You drive forward, you turn around somewhere, and you come back and turn right. That's how you do it. But you don't turn left just because you decide you can. You decide you want to. It's wrong. Anyway, thank you guys so much for watching, and I'll see you another time.